Welcome to another tutorial from SA Labor Help. One of the biggest issues when it comes to disciplining an employee within a company is to first identify whether the issue at hand is that of a discipline issue or whether it is an issue relating to poor work performance of the employee. There have been countless situations when disputes are referred to the CCMA for an unfair dismissal dispute because the employee would allege that the company or employer failed to follow the correct procedures before dismissing him or her. Failure by a company to follow proper pre-dismissal procedures before dismissing an employee may lead to an unfair dismissal, at least in terms of procedural unfairness. In this tutorial we will shortly distinguish between poor work performance dismissals and disciplinary dismissals. Poor work performance is the failure of an employee to reach and/or maintain an employer's work performance standards. Poor work performance is not based on fault and therefore can be differentiated from misconduct processes. Like ill health, it falls under the heading of incapacity. In the case of Goldfields Mining South Africa versus the CCMA and others 2014, the court explained this concept and distinguished between incapacity and misconduct as follows. Incapacity relating to poor performance is prevalent where an employee has persistently failed to meet certain performance standards despite the employer offering training, guidance, assistance and evaluation. In such a case, the employee would potentially lack the skills, knowledge, or competencies to meet the employer's standards. In this case, the problem lies with the employee's aptitude. Although willing to do what is required, he or she is unable because of some factor linked to the employee that he or she has little or no control over. A dismissal for misconduct is based on the employee's fault, in other words, intentional or negligent non-compliance to company rules or standards. A degree of blameworthiness is therefore ascribed to the employee. Items 8 in brackets 2 and 8 in brackets 3 of the Code of Good Practice, dismissal in Schedule 8 of the Labor Relations Act stipulates that Item 2, after probation, an employee should not be dismissed for unsatisfactory performance unless the employer has given the employee appropriate evaluation, instruction, guidance, training, or counseling, and after a reasonable period of time for improvement, the employee continues to perform unsatisfactorily. 3. The procedure leading to a dismissal should include an investigation to establish the reasons for the unsatisfactory performance, and the employer should consider other ways, short of dismissal, to remedy that matter. This means that an employer must set out reasonable, lawful, and attainable work performance standards in the workplace which must be known by the employee. It is best practice to set out these standards in writing by way of workplace policies in the contract of employment. An employer should then measure the employee's performance against the set out standards. If the employee fails to meet the standards, the employer should consult and inform the employee that she is not meeting the required standards. The employer should endeavor to identify and rectify the causes of the poor work performance by way of further training, guidance and counseling, and give the employee a reasonable period of time in order to improve her work performance. If the employee's performance still does not improve, the employer should embark on a series of poor work performance inquiries which may lead to the employee's dismissal. Poor work performance is a valid ground for dismissal, however, is imperative that the employer follow the process as set out in the Code of Good Practices. Identifying the difference. It can be hard to tell the difference between misconduct and poor performance at first. However, the differences are actually quite simple. The reality is misconduct has more to do with a person's behavior, while poor performance involves a person's ability to do their job. An employee who is good at their job can still take part in misconduct. For example, swearing at a customer or bullying another employee. To establish whether a situation involves misconduct or poor performance, ask the following questions in relation to the employee's role in the company. Is the quality of work acceptable? Is the employee putting in enough effort to complete the job? Is it a form of negligence, I don't care, as opposed to intentional misconduct? If the answer is no to any of these questions, It could be a performance issue and should be handled as such according to the guidelines in the Employee Handbook and Employment Agreement. The management of matters relating to misconduct. Misconduct can occur at two levels, being misconduct and serious misconduct, and should be managed accordingly. In the case of misconduct, blame is involved. It can be intentional or negligent. This means that the employee is able but unwilling to meet the required standard of conduct. Thus, the employee has breached a workplace rule. Most cases of misconduct lead to a verbal or written warning issued by the employer. These warnings clearly outline an explanation for why the warning was given, the standards and expectations of the company, what the employee must do to improve their behavior. In the case of repeated misconduct, the employer must conduct a fair investigation and disciplinary process for each count of misconduct, whether the behavior is the same or completely different. Serious misconduct is any behavior which destroys or undermines the relationship of trust and confidence between the employer and employee. To differentiate between serious or gross misconduct versus a lesser form of misconduct, the employer should test it against the following. Test to determine misconduct. The employer should ask and answer the following questions. Did the employee break a rule or standard regulating conduct in the workplace? Was the rule valid or reasonable? Was the employee aware of the rule? Was the rule consistently applied? Would dismissal be appropriate? If an employee is found to have taken part in serious misconduct, they may receive a first and final warning or be immediately dismissed, but only according to employment law requirements. How to manage cases relating to poor performance. Managing poor performance is not a form of discipline and should not make the employee feel like they have done something wrong, as no blame or fault is involved, but the employee is unable to meet the required standard of performance. The following tests should be applied to determine cases relating to incapacity. Did the employee fail to meet a performance standard? Was the standard reasonable/achievable? Was the employee aware of the required standard? Was the employee given a fair opportunity to meet the standard? Would dismissal be the appropriate sanction for not meeting the required standard? What alternatives to dismissal have been considered? Poor performance can be resolved in an informal or formal manner depending on the seriousness of the problem. Sometimes a bit of extra verbal feedback and mentoring is enough to resolve performance issues, while other cases require a more structured approach. A performance improvement plan is an effective, long-term strategy that helps employees identify weak areas and get the help they need to improve their performance. By following this procedure with care and respect towards the employee's individual needs, it is possible to resolve these issues and maintain a positive working relationship. If this plan does not work, it may be necessary to allocate the employee to a different position or consider dismissal. This last option should only be considered if all other avenues have been exhausted. Thank you for taking part in this tutorial. Should you require further assistance, please press the booking button on the application to send an email to request either a telephonic, Zoom or Teams consultation. Or even should you require a SA Labor Help Panel member to chair either a disciplinary or incapacity hearing to arrange a date, time and place of the hearing. Prices will be quoted to you in terms of your needs as per the mail sent through the bookings button request in our application. Please allow a maximum turnaround time of 24 hours for our officers to reply to a booking request by yourself or your company.